Hi, my name is Alina Altamirano. I'm an estate planning attorney in Boca Raton, Florida, and today I will be answering some of the most common questions that we get either as a follow-up to our webinar or as questions that come from our website regarding estate planning and probate. The first question is, what's the difference between a will and a trust, and how do I know which one I need? So a will outlines who gets what you have after you pass, but it does have to go through probate. And a trust avoids probate and lets you manage how and when the assets are distributed. It not only covers the time of after somebody passes, but it also involves times of incapacity. And so the trust helps to plan for both of those instances. The trusts offer more privacy, control, and efficiency, especially when there are larger estates or minor beneficiaries. I help clients decide based on their goals, their family dynamics, and the assets that they have, whether somebody needs a will or a trust. The second question is, I'm not wealthy. It's prefaced this way. I'm not wealthy. Do I really need an estate plan? And the answer would be yes. Estate planning is about control, protection, and most importantly, peace of mind. When you have an estate plan in place, it helps you and your family avoid conflict and ensures that your wishes are honored regardless of your net worth. It also is very helpful whenever there are minors in the family. It names guardians for the children. It sets up powers of attorney. And there are, even more documents that compose a complete estate plan, such as healthcare directives, living wills, powers of attorney for financial and personal matters, etc. Next question would be, what happens if I die without a will in Florida? Basically, the state will decide at that point who will inherit your assets. It's going to be based in the law. It's based on intestacy laws. That's the term for somebody dying without a will. They died intestate. This may not reflect your wishes. It can certainly, most of the time, delay distribution. And it also creates stress for loved ones at an already difficult time. You want to allow your family to be able to grieve without having this extra stress of a court process, dealing with attorneys, dealing with each other, which is sometimes more difficult than dealing with attorneys. But in any event, you're subject to the state laws, the judge's calendars, the attorney's calendar, and everything else that comes in between. The next question is, how often should I update my estate plan? This is a common question for people who already have an estate plan, or maybe they moved from a different state. There's something that they did a long time ago. In my opinion, this is something that should be reviewed every 3 to 5 years. You have an estate plan that can be revoked or amended, changed in any way. This is not when it comes to irrevocable plans. Definitely, you should review it also after any life changes. If you had a birth in the family, a death in the family, if there has been any type of divorce, if there's a move or a major asset change, at that point, your plan should be reviewed and probably revised. I offer reviews to make sure that everything is still aligned with your current wishes and your life circumstances. I do not charge for the first time that we sit down and review any existing documents. I just want to make sure you're set. And if the documents are great, then that's perfect. You can just move on with that and no charge would be due at that point. But if something may need to be revised or changed or amended in any way, then at that point we discuss the pricing for whatever needs to be done at that point. What documents are included in a basic estate plan? Typically, this includes a will or a trust. If you have a trust, it also probably has a pour-over will, but it's mainly the will or a trust, then a power of attorney, healthcare directives, and HIPAA disclosure, living will, and final disposition instructions, which determine what will happen with your body when you pass. Each document serves a specific purpose, whether it's planning for incapacity or death or both. The next question is, what is probate and why do people want to and try to avoid it? Essentially, it's because people want to avoid court processes. Probate is the court process that will validate somebody's will and transfer their assets upon their death. This process can be slow. It is a public process, so all your family's information is going to be exposed, and it's also costly. Most people try to avoid it because it is a burdensome process. A trust and proper planning helps to bypass the probate. This will save time and reduce hassles. How long does the probate process usually take? That's our next question. How long does the process take? It depends. It is often about 6 months to a year. In some cases, it can take years before things are actually resolved. Delays can happen if there are disputes, if there are debts, if there are court backlogs. I mean, judges are people. Things happen to them too. They have schedules too, and they are pretty packed at this time. Good planning can definitely shorten or even avoid this timeline altogether. Next, the question says, if I am named the executor of someone's estate, what am I responsible for? You're going to have to handle debts, taxes, court filings. You're going to be dealing with attorneys. You're going to be dealing with documents, distribute assets according to what the will says once the court approves the will, or if it's regarding a trust, then whatever the trust says. It is a big job. So professional guidance may help you avoid any mistakes and stay organized in the process. Next is, can probate be handled without going to court? Nope. The answer is clear there. Probate is not going to be handled without going to court. So the only way that you can avoid probate court will be through transferring assets during your lifetime. And that's where a trust is the most helpful. What happens if family members disagree during the probate process? We have delays, we have headaches, we have increased legal costs. That's always an issue whenever there are disputes in the family. So mediation sometimes is necessary in order to resolve the issues. But if we have a clear estate plan, that will definitely prevent any confusion. How can I make sure my children are taken care of if something happens to me? You should name legal guardians and use the trust to manage any inheritance that they may get until they're mature enough to be able to handle those assets. And you should definitely plan for both financial and emotional care. That's it with the questions for today. We'll be back for more.